Hi, everyone. Welcome to our webinar on what SaaS businesses need to know about data privacy and cybersecurity. It's great to have you here. My name is Harmanjot. I'm a senior associate in the commercial contracts team here at LegalVision. I've been working in the data privacy space for a few years now, so this is kind of my area of specialty. Before we begin, a couple of quick housekeeping items. You will receive a recording and the slides to your inbox, so no need to frantically take notes if you don't want to do so. There will be a Q&A at the end, so during the webinar, feel free to submit your questions in the Q&A box, and we'll get to them at the end. And at the end, there will also be a feedback survey, and we'd really appreciate any responses that you're able to submit. By attending this webinar, you're eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business. To claim your complimentary consultation, leave us your contact details in the survey that pops up at the end, or contact us via our website. Before we begin, I'd just like to do a bit of a quick poll to kind of understand what everyone is here for. So there will be a poll question popping up on your screen shortly if it's not already there. We want to know what aspects of data privacy and cybersecurity your SaaS business is most concerned about. Is it complying with data protection laws? Is it navigating the legal landscape for marketing? Is it drafting necessary legal documents, maintaining customer trust and reputation? Or is it all of the above, or are you not really sure and you're just here to learn? So I'll give you a couple of minutes now to pop your answers in there. Okay. So a pretty even answer there. Most people are kind of here to because they're concerned about all of the above. So that's great to hear. These are all things that we'll be covering in the webinar today. So we'll go through what is cybersecurity. We will have a bit of an overview of the legislation before we touch in a bit more detail on the Data Privacy Act and the Data Use and Access Act. And then we'll talk about marketing your business and the documents that you'll need to ensure that you're compliant. And then we'll also wrap up with some practical tips for compliance. So before we can dive into what you need to know about data privacy and cybersecurity, we need to talk about what we actually mean when we talk about cybersecurity and why it's relevant to data privacy. So, cybersecurity is a term that is often loosely thrown around whenever there are conversations around online systems and the safety of such systems. The technical definition of cybersecurity is the art of protecting networks, devices, and data from unauthorized access or criminal use, and the practice of ensuring confidentiality, integrity, and the availability of information. So, on the flip side, a cybersecurity incident is an unwanted or unexpected cybersecurity event or a series of such events that either has compromised business operations or has a significant probability of compromising business operations. Some common types of cybersecurity incidents include hacking, so the unauthorized access of a system or network, often to exploit a system's data or manipulate its normal behavior. Once in, a hacker can access any information stored on your systems, obtain passwords, intercept messages, and generally watch what you are doing. Another common type of attack is a ransomware attack. This is a common type of malware in which malware is used to encrypt the victim's files or block access to their systems. A ransom, usually in the form of cryptocurrency, is then demanded to restore access to those files. In some cases, the ransom is demanded to prevent data and intellectual property from being leaked or sold online. Then you've also got phishing attacks. These involve impersonating people within an organization to trick other employees into revealing confidential or otherwise sensitive information. These attacks gain a financial benefit either by using the information, such as credit card details, or by relying on the recipient to take an action, such as paying an invoice or changing access requirements on a bank. A cybersecurity incident often targets personal data, and this is why it's important to think about your data privacy obligations alongside thinking about your cybersecurity measures. Last year, the government released a report detailing the state of cybersecurity in the UK. It was revealed that in the UK, 50% of all businesses had experienced some form of a cybersecurity incident in the last 12 months. In recent months, we've witnessed huge cybersecurity incidents impacting large retailers like M&S, Co-op, and Harrods. M&S in particular was reportedly subject to a ransomware attack, the impacts of which are still being felt more than 2 months after. The attack caused some of its systems to be out of action for more than 7 weeks and resulted in a notifiable data breach to the ICO, as the attack involved customer contact details, dates of birth, and online ordering history. This incident is reported to have cost M&S at least £300 million in losses. So as you can see, they really do have the ability to cause a fairly significant impact on business operations. As a SaaS provider, you have an obligation to ensure that you are protecting the personal data of your customers, and where your target market is businesses, any of their customers whose personal data may be inputted into your SaaS. So now that we know what a cybersecurity incident is, let's run through what legislation we actually need to be thinking about here. So the relevant legislation, there's a couple of pieces here. We've got the Data Privacy Act. This is the key piece of privacy legislation, and it also includes the UK GDPR, which we'll refer to as just the GDPR throughout this webinar. The GDPR governs the processing, movement, and protection of personal data by businesses. We've then got the Privacy and Electronic Communications Regulations 2003, otherwise known as the PECR. The PECR is the primary piece of legislation governing marketing activities undertaken by businesses alongside the GDPR. It governs the use of cookies and sets out the rules around the requirements for undertaking direct marketing. And then we've got the Data Use and Access Act. This one is fresh. It only received royal assent last month, and it's still in the process of being implemented. It places significant new obligations on businesses in handling personal data and introduces new enforcement powers for the ICO, or the Information Commissioner's Office, which is the regulator of all of this privacy legislation. Before we can dive into what obligations a SaaS business has in respect of data privacy, we need to understand some key concepts in the GDPR. The primary obligation in the GDPR is to protect the personal data of individuals and to handle that personal data in a transparent manner. In addition to the obligations that you may owe to individuals, the GDPR also includes obligations between businesses. So there's a concept of a controller and a processor, and your obligations under the GDPR will be different based on whether you are acting as a controller or a processor. So it's important that you identify which category you fall into. It's also important to note that you can be both. So you can be a controller in one situation while acting as a processor in another. That's particularly relevant for SaaS businesses, as we'll talk about in a second. So a controller determines what personal data to collect and how to process that personal data. For example, if you collect a customer's name and contact details as part of signing them up to your service, you will be the controller of that personal data. A processor, on the other hand, processes personal data on behalf of a controller and does not determine how to process that personal data themselves. So many B2B SaaS businesses, such as Stripe and Xero, are considered to be processors when their customers input personal data into their platforms or when they collect personal data from individuals on behalf of their customers. Another common example for B2B SaaS businesses is a situation where you collect personal data from a contact at your customer's company, and then later in the use of your SaaS solution, the company inputs their end user's personal data into your SaaS solution. In this scenario, you would be a controller of the personal data collected about the contact at your customer's company and a processor of any end user personal data they may input into your SaaS solution. So now that that's out of the way and we have an understanding of what situations you're a controller in and what situations you're a processor in, or which situations you're both in, what are the obligations that you actually have? So as we touched on, certain obligations apply only to controllers, while certain obligations apply only to processors, and then there are some that apply to both. So some of the key obligations for a controller include identifying a lawful basis for processing each piece of personal data. So there's now seven lawful bases to rely on, and if you don't fall into at least one of those lawful bases, you can't collect that piece of personal data. You also need to have a compliant privacy policy and pay a data protection fee to the ICO. If you're a processor, some of your obligations include only processing personal data on the instructions of the controller, obtaining consent from the controller before engaging any sub-processes, and notifying the controller of any personal data breaches. So the one thing you'll note there is that for a controller, the obligations are in respect of the individual or the data subject, whereas for a processor, the obligations are in respect of the controller. It is then the controller's role to manage that relationship with individuals and make sure that an individual's privacy rights are being adhered to, and a processor simply assists in that process. Some obligations that apply to both controllers and processors. The first is to implement security measures, both organizational, such as internal policies, and technical measures, such as software, to protect the personal data. And then there is an obligation on both parties to enter into a contract between themselves, so between a controller and a processor, to make sure that personal data is being handled in accordance with the law and that both parties are aware of each of their obligations in respect of that personal data. So what does the Data Use and Access Act now mean for the Data Privacy Act and the GDPR? As we touched on, the Data Use and Access Act is very fresh. It only received royal assent last month, and it makes updates to existing privacy and marketing laws. We briefly touched on the fact that a controller must have a lawful basis to rely on to process personal data. There were previously 6 lawful bases, and the Data Use and Access Act introduces a 7th. This is known as the recognized legitimate interests basis. The legislation provides examples of processing that may qualify as legitimate interests. So if you fall into that category, there is, in terms of the sort of assessments you need to do before relying on that, there's less obligations on the business that is relying on a recognized legitimate interest. Another key change under the legislation is an introduction of an obligation that requires businesses to protect children using online services. So if your SaaS is aimed at or is likely to be accessed by children, you need to consider how children can best be protected when using your services, account for children's different needs at different ages and development stages, and recognize that children may be less aware of data processing risks and their rights. So as a SaaS business, you now have an obligation to prioritize the privacy of children when designing your systems and procedures. Okay, the next is automated decision making. So where your SaaS solution undertakes automated decision making, there are now more detailed requirements that you must comply with. There is now a wider range of situations in which a business may make solely automated decisions as long as it has appropriate safeguards in place. These safeguards include providing the person whose personal data is being used with information about the decision, enabling them to make representations about and challenge the decision, and enabling them to interact with a human as part of the automated decision-making process. So provided that you've got these safeguards in place, there is now a greater sort of list of circumstances in which your business can undertake automated decision-making. The other relevant change introduced by the Data Use and Access Act is some new exceptions to the cookie consent requirements. These relate to strictly necessary functions. So that was an exception that already existed, but it now also applies to statistical purposes, provided that an opt-out is available, and website functionality enhancements. So you may not strictly need consent where you are using cookies for these purposes, provided, as we just flagged, that you have an opt-out available. There are also some new enforcement powers that have been introduced for the ICO in relation to the PECR and marketing, but we'll touch on those shortly. So then how do you actually market your SaaS business? Leveraging email marketing and using cookies on your company website is essential to growing your business these days. But in doing so, you must be aware of your obligations under the PECR and the GDPR. The first thing to note is that there is no restriction on sending solicited marketing. So that is where an individual has specifically requested that you send them marketing material or send them information about your services or a particular product. There is no restriction on that because they've specifically asked for it. You can send them that material. Outside of that, generally you will need to rely on consent to send any direct marketing. So, for example, any text messages, any emails, unless an exception applies. So, for consent to be valid under the GDPR and the PECR, it must be knowingly and freely given, clear, and specific. This means that an individual must have a genuine choice as to whether they receive the marketing material. They must be informed about what they are consenting to. The consent must be specific to each scenario. So, for example, you would need a separate consent for email and another for text message and another for any direct calls, as an example. And then finally, consent must be given via a positive action, meaning they have to check a box or click an accept button in order to show that they have given consent. Having a pre-ticked box or a pre-checked toggle is not going to be valid consent under the legislation. One exception to consent is known as a soft opt-in, and this applies to existing customers. You can send marketing material to an individual where you have obtained their contact details in the course of a sale or in the course of negotiating a sale with them. You're marketing your own similar products or services. And at the time that you collected their details, you gave the individual the opportunity to opt out of receiving marketing material. You must also then provide the individual with an opportunity to opt out in every marketing message you send to them subsequently, and this must be via a functional unsubscribe button. So, for example, at the bottom of the email, if you have an unsubscribe link, it must actually work. It can't just be for show. The other exception to consent requirements is for corporate subscribers. A corporate subscriber is a corporate body that has a separate legal status. So, for example, companies. You can send direct marketing material to a business. However, there are some nuances to consider here. In particular, sole traders and partnerships are not considered corporate subscribers. And therefore, if the business you're marketing to operates through either of these structures, you'll still need to comply with the consent requirements. Additionally, if you are marketing to a particular person at a business, you need to make sure that the marketing is relevant to their role within the business. So, for example, if you are an accounting software, for example, and you're sending marketing material to the HR person, that's probably not compliant and likely to fall within that exception there. So you would send that marketing material to someone in the finance team, as an example. In all marketing material, you must clearly identify your business and provide your contact details. You must also provide the ability for recipients to opt out, both for individuals and for corporate subscribers. As we briefly touched on earlier, the new Data Use and Access Act introduces greater enforcement powers for the ICO in relation to breaches of the PECR. As a result of this, businesses can now face fines of up to the greater of £17.5 million or 4% of their global annual turnover for violations of the PECR. So that's in respect of those marketing rules that we've just spoken about and in respect of any cookie consent requirements. So as you can see, fairly substantial sort of consequences now where you are failing to comply with the marketing rules that apply to your business. So it's always good to make sure that you're across any updates like this so that you can make sure that you stay compliant. All right, so we've talked about what your obligations are and what you need to do when you're marketing your business, but what documents do you actually need to make sure that you are compliant? So the first would be a data processing agreement. This is a legally binding contract between two parties that states the rights and obligations of each party concerning the protection of personal data. So this is that contract between the controller and the processor that we touched on earlier. It should be used every time a data processor is appointed to process personal data. If your business is a data processor, such as a SaaS business, we recommend that you have your own data processing agreement that you can provide to your customers so that the document is on your terms. Next, you've got a privacy policy. So even where you are a processor in most circumstances, there are likely to be certain situations in which you are a controller, and therefore you should have a privacy policy in respect of any personal data that you collect or process as a controller. A privacy policy is a document that tells individuals how you process their personal data. It tells them what personal data you collect, what you use it for, who you share it with. It should also include your contact details and information on the rights that the individual has under the GDPR. The GDPR specifically sets out what must be included in your privacy policy and how it must be made available to your clients. Your privacy policy must be freely and easily available, such as on a page on your website. And you should also provide this to individuals when you collect their personal data. So, for example, when an individual is signing up to your SaaS platform, you would have some sort of language that directs them to your privacy policy and lets them know that you handle their personal data in accordance with your privacy policy. Next, we've got an international data transfer agreement. This applies if you are transferring personal data overseas. For example, if you have a sub-processor based overseas, typically you will need to enter into the standard contractual clauses or an international data transfer addendum to protect the transfer of that personal data. These can be built into and incorporated into your DPA or your data processing agreement. You should also have an internal privacy compliance manual. This is an internal policy on how your business handles personal data. So it should include information about what types of personal data you collect, how you store it, and who's responsible for it. It should also set out what your team needs to do should they receive a request from a data subject or if there's a data breach. So essentially, it is a policy telling your team how to comply with the GDPR and making sure that they're then assisting you in meeting your obligations. And then finally, you should also have an internal privacy register. This is a log of all of your privacy related decisions, including what lawful basis you have relied on, any data subject requests you've received, any data breaches you've experienced, and any data protection impact assessments that you've completed. This will ensure that you have a paper trail and an accurate recollection of events that have occurred should the ICO request any evidence of compliance from you. Okay, so finally, I'd like to go through some practical tips for complying with the GDPR. So I've told you about your obligations, I've told you what documents you need, but what do you need to do in practice? Firstly, familiarize yourself with the rules. Make sure you understand your obligations, know whether you're a controller or a processor or both. Know how and when you can market your business, and put in place procedures to ensure that these rules are complied with. Educate your team. So run cybersecurity training to ensure that your team knows how to identify vulnerabilities. Ensure they know what to do in the event of a cyber attack, but generally also ensure that they know what your obligations under the GDPR are and what their role in assisting you with meeting those obligations is. To also recommend you put in place your privacy documentation, so all of those things that we've just talked about. Have the right documentation drafted or have it updated if it already exists, and ensure that your team know how and where to find it. Now, at a minimum, you should be ensuring that your privacy documentation is revisited every 12 months, especially your privacy policy. So make sure that it is still current, it still reflects your privacy practices as they are at the moment, and that it is compliant with any changes in law. You should also strengthen your cybersecurity measures. So implement multi-factor authentication, conduct regular software updates and data encryption across your systems, implement organizational policies for protecting personal data, and to assess your own compliance with the GDPR. And then from a technical perspective, implement those technical measures to detect cybersecurity attacks, set up processes to detect cybersecurity attacks, and have a plan for how you will respond in the event that you are subject to an attack. And this is where that internal privacy compliance manual and that data breach response plan comes into play. So that concludes the main part of our webinar. You might find our publication on personal data breach notification fact sheets really useful. There's a QR code that you can scan on your screen, or when the slides are emailed over to you, the QR code will also be in there. We also have an upcoming webinar on corporate governance for SMEs, staying compliant and managing risk. You can register for this at the link on your screen or at our website. Okay, we'll answer your questions shortly. While you submit them, we're going to take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers for all of your business's usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with a number of things, including unlimited document drafting and reviewing, unlimited legal advice consultations, unlimited trademark registrations, corporate structuring, employment law assistance, HR assistance, things like that. As a LegalVision member, you don't have to worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of your business's usual legal work so you can focus on running your business. And if you are in-house legal counsel, we also offer a dedicated service to manage your high volume business's usual legal tasks. So get in touch. You can request a free consultation when the survey appears at the end of the webinar, or contact us via our website and we'd be happy to assist. Okay, time for some questions. What is the CEO's responsibility under the Companies Act UK in terms of breach of data privacy and cybersecurity by the employees? So that's a good one. The data privacy and cybersecurity obligations at law lie with the business, not its employees. So it is up to the business to ensure that it, and by extension its employees, are compliant with the applicable laws. And this goes to some of those practical tips we discussed earlier about making sure that your team is educated on their obligations under the GDPR. They know where to find the information, and they know what to do in the event that something does go wrong. As we touched on earlier, the fines for non-compliance are pretty significant. It's the greater of £17.5 million or 4% of the company's total annual global turnover. So I guess the risk of getting it wrong is quite significant there. Directors of a company, in addition to sort of the consequences for the company itself, directors can also face personal liability if the breaches are committed with their consent or due to their negligence. And then we also need to think about whether the breach of privacy and cybersecurity laws was the result of a breach of a director's duty under the Companies Act. So that will kind of depend on the extent of the breach or the the privacy laws as well. Some of the ways that you can try and manage this risk, like we touched on, ensure your employees are across their obligations under the applicable legislation, run regular training and repeat that training. So, every 12 months or so, do a refresher so that it stays front of mind. Have internal documents that point your team in the right direction when they have questions, and have a designated point of contact that is kind of like your specialist in the GDPR, whether that be someone internally or your legal team. Okay. How can we obtain consent to market our services via email? So consent under the legislation, like we touched on, needs to be knowingly and freely given, clear and specific. It needs to be given via an affirmative action. So for example, by the customer actually ticking a box or toggling a field. It can't be pre-checked because this wouldn't require an affirmative action on the individual's part. It also needs to be clear what the individual is consenting to. So you need to set out that they will be receiving marketing material via email or via text message or whatever other method you'd like to use. As we discussed earlier, the other option is to rely on a soft opt-in. So if you're going to go down this route, rather than having specific language allowing you to send marketing material to the individual, you would have opt-out language instead. So the same concept still applies. You still need that tick box or a toggle or something along those lines, except this time you'll be asking the individual to let you know if they do not wish to receive marketing material from you via a specific channel. All right, any more questions? How do we market our business to international customers? Okay, so if you're marketing your business internationally, you will need to familiarize yourself with the data privacy and marketing laws that apply in your target jurisdiction. So, as a business established in the UK, you will always need to comply with the GDPR and the PECR. However, you may also need to comply with local legislation in your target jurisdictions. So, you'll need to do some research there or engage some local lawyers to make sure that your marketing campaign or marketing strategy is kind of compliant with the jurisdictional laws there. Okay, I think we've probably got time for one more. Do our internal privacy registers need to be in a particular format? That's a really good question. No, so the ICO and the legislation do not dictate what form your privacy register needs to be in, just that you have to have appropriate records of any privacy decisions you make or requests you receive. So you should also keep records of any privacy events you've had, for example, any breaches and the actions that you took arising from that. So here, it kind of depends on what works best for your business, whether you prefer it to be a Google Sheet or an Excel spreadsheet, or if it's just you've got a software that handles this request, this register for you. Whatever form you choose to do it in, you need to make sure that you've got some good backup copies of it, so that if the ICO does come knocking, you know exactly where to find it. Okay, I think that's all that we have time for today. Sorry if we haven't answered your question. We'd certainly love to help. So submit your details in the survey at the end, and we can try and answer your questions in a consultation with you. While this webinar is free, we do value your feedback, so we'd really appreciate you taking the time to complete the 30-second survey at the end. Thanks so much for joining us.